Good morning once again, and welcome to our second session of the second day. So first, we've had a short but exciting session on law and technology, which left many further questions to be asked, which I'm sure will continue on over the lunch break. And I can't but wonder about what Professor Padin said today, that we need to return the humans into the philosophy of law, whether their absence is connected to the same processes of datification that the previous session has talked about. But now we are returning to some more classical subjects, and this longer session is called Justice in Theory. Our first speaker for today is Stefano Fuselli, who will be talking about otherness and good in Aristotle's general justice. I'll share your presentation. You have the remote, yes, just on this one. The floor is yours.
Thank you. First of all, thank you very much for having accepted my proposal and for let me come here to Belgrade, where I met a lot of friends, old and new friends. Okay, the starting point of my presentation is the fact that traditionally philosophers of law and legal theories have dealt with so-called particular justice, that is distributive or corrective justice. But the so-called general justice was quite neglected. This is the reason why my aim is to focus on some aspects of general justice, dikaiosine, as a virtue, that is a subjective disposition or state of character to act deliberately according to the right mean. This is the definition of Aristotle in the fifth book of the Nicomachean Ethics. And more specifically, I will examine the so-called general legal justice in shedding light on two constitutive aspects that are the role of otherness and the kind of good justice aims at. And I do not intend to consider those profiles that more specifically concern the objective right, to dikaion, that is, broadly speaking, what indicates a specific value or connotes a behavior or a rule of a situation. Well, we will proceed as follows. After briefly recalling the political scope of Aristotle's Ethics, we will recap what he says about general justice. We will examine the difference about the role and types of other and good in justice compared to other virtues, and conclude with a glimpse at justice as a mean, mesothet. Well, an examination of the virtue of justice cannot ignore Aristotle's general concept of ethics. According to Aristotle, ethics is a practical science. Therefore, it aims at knowing the causes, the ways, and subjective and objective conditions of action. More specifically, ethical problems fall within the broader horizon of political science. Indeed, the object of ethics, that is the good, is also the object of politics, most truly the master science, architectonike episteme. This also applies to justice, dikaiosine, which is the virtue proper to the city, dikaiosine politiko, that virtue which ensures the order of the political community by allowing one to judge what is just, and therefore justice is a social virtue, koinonike, that is inherently intersubjective and is connected to all other virtues. In the Nicomachean Ethics, Aristotle qualifies universal justice as lawfulness and as a perfect teleia virtue. Observing the laws means doing what is just, because the laws identify and determine in every area what is the common good, to koine sympherontos, that is, everything that is functional to produce or maintain the eudaimonia of the political community or its parts, and everything that contributes to its realization. Aristotle provides the following reason for the alleged perfection of justice. Justice is the perfect virtue, not in general or in absolute sense, but in relation to other people. Justice is perfect in the highest degree because it is the use of perfect virtue. Justice is the perfect virtue because those who possess it also use it toward other people and not only toward themselves. This orientation toward the otherness is also what makes justice different from the other virtues, since as justice is the only virtue that is the other's good. In other words, virtue in general and justice differ precisely because the latter necessarily implies relationship with others. Due to its concrete exercise in relationship with others, every virtue is comprehended in it, in justice, so that this form of justice is not a part of the virtue, but is the whole virtue. Aristotle himself articulates the relationship between justice and other virtues in 3 steps. In the first, he recalls the saying that all the other virtues are comprehended in justice. In the second, he states that this universal form of justice is not a part, meros, of virtue, but is the entire virtue. In the third, he declares that the essential difference between virtue and this form of justice concerns their being and is due precisely to their relation to otherness. At the first sight, these statements are Aristotelic, if not contradictory, because on the one hand, all virtues are brought together in justice to form a whole. On the other hand, there remains an essential difference between justice and the other virtues, precisely because of the relationship to otherness. It is my view that a good way to resolve this apparent dystonia is the one suggested by a commentator of Aristotle, Diermeier. He reads these pages in direct relation to Plato's Politeia, the Republic. Diermeier claims that even in Plato, justice is the respect for the conditions that make the city flourish and preserve it according to what it established by the laws. However, while in Plato justice develops in inward direction as an activity directed towards the inner entos praxis, towards the harmony of the soul, in Aristotle justice instead refers to the other and is therefore realized in an activity directed toward the other, the outer exopraxis. I would like to look at this idea from a slightly different point of view. Even according to Plato, justice is the virtue that gathers all the other virtues into itself. This is not because it summarizes their characteristics in itself, nor because it is a kind of common genre. It happens because justice is the condition of possibility for the best possible exercise of the other virtues. It allows them to develop and maintain themselves, creating that harmony that binds together all the components of the city and all the components of the soul. Similarly, Aristotle's legal justice is the entire virtue, not because it represents their common genre, or because it is the result of their concurrence, but because it is, so to speak, the whole of the virtues, the one through which each virtue can flourish. In fact, this form of justice is the one that is concretely exercised in those behaviors that are functional to the happiness of the polis and his preservation. Therefore, it is precisely this virtue that creates the condition for all virtues to be acquired and exercised. That is the creation of a political community within which only, it's a Greek, perspective, human beings can be fully themselves and can aspire to happiness. Justice cannot be complete except as an active disposition to put into practice what is necessary to live according to the human condition, that is, to live in a political community. The reference to otherness is also found in other virtues, such as liberality, magnificence, urbanity, friendship. Nevertheless, it seems to me that in each of these virtues, the beneficiaries of virtuous action are characterized by a particular aspect. On the other hand, in the treatment of justice, the otherness is presented, at least initially, without any particular connotation. Justice is the concrete exercise of virtue in relation to others, whose good one seeks to achieve, but because they are others as such, and not because one is fulfilling some kind of obligation, not because one is in a personal relationship with them, not because there is already a bond of reciprocity like in the other virtues. From this point of view, justice can be realized in so much in a fulfilled form only insofar as it is capable of making room for the other as other. There can be justice only where the otherness of the other is accepted and preserved in the achievement of his her good. Insofar as it is a disposition, justice requires as a concrete condition of its exercise that there is a present capacity to see the other as such and to recognize him or her as such. Then, universal justice aims at the good of the other insofar as he, she is a human being among the human beings. There is no doubt that this good belongs to the category of useful, that is functional to the happiness of the polis. At the same time, however, this utility, at least at the level of general justice, is neither limited to the realm of monetized goods, as in the case of liberality or magnificence, nor to the pleasure-pain alternative, as in the case of urbanity, nor is connoted by a particular reciprocity of return or effective, as in the case of friendship. Rather, it can be understood as that which, by preserving the other in his her otherness, at the same time also preserves that framework of relations stabilized in the polis, in which alone and properly one can realize his her humanity, and thus his own eudaimonia. By preserving his constitutive politicalness, it also preserves the concrete condition for his full realization. Aristotle says that it is equally unjust to give too much or too little without respecting equality according to proportion, para to analogo. That aspect in which justice consists in respecting equality without incurring excesses or defects constitutes the proper scope of particular justice in both its forms, distributive and corrective. Both forms of justice require that in order not to incur excesses or defects or to restore broken balances, proportion, it has analogy, be used. Some features of the way Aristotle defines the uses of and uses the notion of proportion or analogy are worth mentioning briefly. Analogy, which according to Aristotle always implies the presence of at least 4 terms, is an equality not of terms but of their relations. Therefore, analogy preserves the difference among the related terms in the very moment it connects them without producing homogeneity, homologation. Like justice, analogy requires not only the presence of otherness, but that this itself be preserved. And this is why, in my opinion, analogy is the rule for the exercise of justice, where it is a matter of managing relations among the consociates in relation to the goods they desire, they expect, they claim. Thank you.
Thank you very much for your very interesting presentation. We are moving on now to Professor Vassilis Voutsakis with his subject, the political function of the right to do wrong. I will also share your presentation.
Thank you. And I would like to start by thanking the organizers for accepting my proposal. And moreover, I would like the organizers for the warmth and the hospitality we are all witnessing the day before and today. Before starting, let me start with some remarks, some introductory remarks. First one, according to a well-known tendency, political realism, politics is not related to morality. If we take Bernard Williams' word, he's, as always, clear. According to him, politics is not applied to morality, and instead he's eager to propose an approach which gives a greater autonomy to distinctively political thought. One basic intuition of political realism is that modern societies are riddled with so many disagreements among individuals or groups that it is impossible, really impossible, to find a common set of moral values. My second point. I think political realism's insight into the centrality of value pluralism in our societies can hardly be disputed. This is why even its most fervent opponents try to do justice to this central feature of contemporary societies. A very popular move towards this direction is the one a great part of the theory has undertaken: the distinction between good and right, that is, between questions of personal morality and questions of the organization of society. These distinctions lie in the heart of proposals such as, for example, the Rawlsian theory of justice. According to that view, politics is not concerned with questions of good life, but solely with questions of right behavior towards other people. Thus, a great part of moral issues is not related to politics. Disagreements on issues of good life are respected as such, hence also the respect of a plurality of values pertaining to questions of personal morality or the sense of life. I do not think that this distinction is devoid of interest. Nevertheless, it is worth mentioning that in our societies, it is not uncommon for there to be disagreements on what is right. The most striking example thereof: dissents in courts decisions. Very often, even the judges of courts, high courts, disagree on the very meaning of constitutional provisions on fundamental rights. So it seems that the distinction between right and good might be of little help here, because judges do not seem to have a set of common moral values on the basis of which they might resolve their disagreement. I do think that at least prima facie, it seems that political realism seems to be vindicated. I will argue, however, that this is not the case. I will not examine directly, but only indirectly, the credibility of political realism's fundamental idea. But I do think that an answer to the challenge of value pluralism can be sought in Immanuel Kant's doctrine of moral autonomy. I will proceed as follows. First, I will present the way Kant deals with questions of right, compared to questions of good. Second, I will present the duties that, according to Kant, other persons have against a person that proceeds to morally deficient acts. In order to give you a simple example, a person who breaks the promise she has made to a friend of hers. Is it possible? Is it morally acceptable to break a promise that you have given? Third, I will present the view of Kant on the claim that the wrongdoer has against other persons. I think this is a genuine right to do wrong. Fourth, I will argue that the implication of this right to do wrong is personal autonomy. And I will finish fifth point with some remarks concerning the relation of the right to do wrong and pluralism. My first point. In the metaphysics of morals, rights, account rights, it is a human being's duty to strive for the moral perfection, but not to reach it, at least in its life. But with regard to perfection as a moral end, it is true that its idea, that is objectively, there's only one virtue. But in fact, that is subjectively, there is a multitude of virtues made up of several different qualities, and it would probably be impossible not to find in it some lack of virtue. Consequently, according to Kant, the person's own moral perfection, and more generally, issues of good life, cannot be the object of a perfect duty. My second point. This is, however, not the case when it comes to the duty of others. According to Kant, it is therefore a duty of virtue not to take malicious pleasure in exposing the faults of others, but rather to throw the veil of philanthropy over their faults, not merely by softening our judgments, but also by keeping our judgments to ourselves. For this reason, a mania for spying on the morals of others is by itself already an offensive inquisitiveness on the part of anthropology. What concerns Kant here is the exposition of the faults of others and the mania for spying on the morals of others. The point he intends to make, I think, becomes clear in the next passage. The essential of vice must never break out into complete contempt and denial of any moral worth to vicious moral being. According to Kant, it is not permissible to put a wrongdoer under the magnifying glass of the blame of other persons. Moral blame, although morally acceptable or even required, runs up against certain limits. It may not go as far as the complete contempt and denial of any moral worth to a wrongdoer. But why? Because, this is Kant's answer, even a wrongdoer should be treated as a moral person. That is, if we would say something else, we would imply that this person, having a fixed nature, something inconceivable for Kant, and I think extremely modern, could never be improved. And for Kant, there is one and only way to assure the improvement of human being, even the most vicious one, by bringing him to understand that he has erred. It seems that according to Kant, the function of moral blame is to persuade even the wrongdoer to do the right thing. But why should the wrongdoer be persuaded and not coerced, albeit in a mild way? I think Kant's answer is very clear and is based upon the concept of moral conscience. Let us follow him. Let us follow him in another passage of the Metaphysics of Morals. Every human being has a conscience and finds himself observed, threatened, and in general kept in awe by an internal judge. And this authority watching over the law in him is not something that he himself voluntarily makes, but something incorporated in his being. In other words, Kant holds that no one else is allowed to interfere into the relationship between a human being and her conscience. The reason is that even a wrongdoer is susceptible to persuasion by her moral conscience to obey the moral law. This is precisely a quality of hers denied by other persons who run up against certain limits when they blame her. The quality of being capable to be persuaded by her own moral conscience. In other words, Kant does not put the wrongdoer on the same level as other persons who blame her for the wrong act she has committed. The fact that a wrongdoer is under the duty to obey her own moral conscience does not entail her being under the duty to obey the moral conscience of other persons. This asymmetry between the wrongdoer and other persons is required in view of the duty of the latter of the persons not to interfere in the wrongdoer's inner dialogue with her moral conscience. What is the point? What is the aim of this asymmetry? This is my third point, and I think a very crucial one, the right to do wrong. It is at this point, I think, that Kant makes the crucial step we are looking for. Let us read the whole passage of the Metaphysics of Morals with which I started. A mania for spying on the moral of others is by itself already an offensive inquisitiveness on the part of anthropology. This is what we saw till now. And then Kant continues, which everyone can resist with right as a violation of the respect due to him. In other words, it seems that according to the text, the duty of other persons to respect a wrongdoer is intrinsically related to the claim of the latter, the wrongdoer, to be respected by them. The duty of other persons is not simply owed to a wrongdoer. It is subject to control by her. How? By her, the wrongdoer, having a claim, that is a right, against them not to spy on her and not to inquire offensively about her. But what is a claim? We lawyers know what a claim is. A claim is a right. To that extent, claims allow persons to play an active role in matters pertaining to themselves. Thus, when Kant affirms that even a wrongdoer has a claim against other persons not to be treated without respect, he means to say that a wrongdoer has a right, a genuine right against other persons, even if he has done something wrong. My fourth point. My contention is that this right is a form of the respect owed to the wrongdoer of her moral autonomy, in order to use Kant's words. And to that extent, her claim against other persons delineates the space within which the wrongdoer is bound to lead a dialogue with her own moral conscience, a space within which she should not be under the gaze of the control of other people. A space, in other words, of personal autonomy. It is in her capacity as an empirical, not a nominal, not a person, as an empirical individual, that the wrongdoer deliberates, makes decisions, and acts. And that space is constituted as such for deeper moral reasons, for reasons of moral autonomy. And then comes my fifth and last point. What have we gained that far? If my argument is correct, Kant seems to endow individuals with the right not to be subject to duties of others. Where does this lead us in the face of value pluralism? The fact that, as we saw in the beginning, political realism takes into consideration and a response in a rather interesting way. On the one hand, we do converge with political realism in its idea that modern societies are riddled with deep disagreements. even when it comes to the fundamental questions of our common life. The right to do wrong endows individuals with a space of personal autonomy, that is, a space within which they have claim against others not to interfere with their thoughts, expressions, or acts, even when they are morally impermissible, and thus also with the right to disagree, even on questions of right. On the other hand, we diverge from political realities, insofar as we consider that it is for moral reasons that personal autonomy should be respected. The political realm is not exempt from morality. That, in other words, seems to enable us to deal with the disagreements that are endemic in our societies in a way that is consistent with a minimal morality based on the duty of mutual respect. Respect that you have one towards each other, or to put it in other words, a morality which recognizes that each human being should be treated as disposing of a space of personal autonomy, circumscribed and delineated by her moral autonomy. That is, a right to do wrong. Nevertheless, it is still possible to say that although interesting, my argument presupposes the acceptance of Kantian morality. I could not agree. I think that the right to do wrong stands in the background of any objectivist moral theory. That is, even if it's utilitarian, archetype, Marxist, the feminist, or the constructionist, provided, of course, that such a theory can accommodate rights. The idea is that an individual has the right to do wrong in the light of any set of objective moral value, and that, by virtue of such a right, even disagreements on questions of right can and should be respected. In other words, the notion of the right to do wrong looms largely and can be a structural element of any moral system pertaining to a form, even moderate, of objectivity. Thank you for your attention.
Thank you very much, Professor Voutsakis. Our next speaker is Konstantinos Farmakidis-Markou, who will be talking about a cosmopolitan duty to naturalize aliens.
Okay. It's the second one.
It should work with the...
Okay. So thank you for accepting my proposal and being so hospitable. I will elaborate a little bit more on hospitality. The cosmopolitan duty to naturalize aliens. So let us first, sorry. Okay. Let us first clarify the question. And first of all, what is a duty? A duty corresponds to a right or a title of enforcement in Kant's words. Is there a right to citizenship? In positive law, to such a right are entitled only the stateless people. There is also a right not to be deprived from a given citizenship. In other words, revocation of citizenship amounts to persecution. Is there a more abstract right to political equality of residents, or the folk, or the puk we heard yesterday in other language? Not in positive law, but only in philosophy. For example, Hegel talks about the duty to confer political rights to Jews as members of Prussian society. And Walzer poses the problem of the modern metoikoi, so the habitual residents that do not have nationality. So minorities and habitually residing populations are good candidates for such a right. of political equality and political participation. In positive law, there's just a wish of naturalization for refugees, and particularly those refugees that cannot be safely repatriated in the Geneva Convention of 1951. But the question is it possible to accept no chance at all or no provision for naturalization or total discretion for naturalization? Or would that violate or weaken compliance with other legal duties of the state? Now, cosmopolitanism. In the common use, cosmopolitanism is considered a cultural trait that might come with some benefits, but implies always a weaker bond or connection with one's homeland. This use is, in my reading, equivalent to what Hegel named abstract cosmopolitanism. He used it to show the reluctance of the Jews to attach themselves to a specific state, which he considered dangerous for the Jews themselves. But in 18th century Germany, cosmopolitanism expressed some kind of deeper conception of the world as open to global exchange, but at the same time constituted by states, themselves further constituted by citizens, not mere subjects. In this dialogue, we have a world of citizens of states rather than a society of citizens of the world without the mediation of the states. Now, what about the alien or the stranger? Legally telling perceptions of the alien are interestingly to be found as early as in the Platonic thought. In the dialogue Sophist, Plato already notes that the stranger is associated with an epistemic fallacy. A lack of a trait, that is Greek identity for Plato, is mistaken for some kind of a common positive trait constituent of the group. So there is no such group as the group of strangers. Strangers are stranger to each other. It's only a relational concept. In the Republic, which we have the first speaker already mentioned, we have a quasi-theological association of peace and friendship with kinship and of war and strife with foreignness and the barbaric outside of the Greek domain. But it is quite interesting that in the dialogue nomoi, begin with a summary refutation of this concept of fundamentally hostile relations and with a new conception of legislation and politics as always striving towards peace. There is no structural war state. A thought experiment is added where a city is established by total strangers, a scenario presented as feasible, not only as feasible, but that might even come with some advantages. They're not bound to bad traditions. The alien, now per se, can now be friendly, is not fundamentally hostile, and deserves the protection of the city's laws, although she usually suffers from inequality before the law. And this protection must be complemented by the protection of gods or of religious customs, if we take a more secular reading. Plato concludes that it is not racial homogeneity or cohesion that guarantees internal peace to the city, but only good laws and the so-called habitation of polis. This is not that clear, and this might, in my reading, and Donatella Di Cesare's reading, this concept of habitation might bring us closer, just bring us to mind a totally different tradition, which is the Jewish tradition, where the resident alien or the ger is not fundamentally different from the native, the Ezrak, if I pronounce it correctly. To be native is to forget one's own history of past immigration. According to Di Cesare's application of those concepts, both native and foreigner, resident foreigner, strive towards conciliation with the political organism they commonly give substance to. This is something like the Stoic notion of oikaiosis, to familiarize, to make something our own. This is, of course, a political interpretation rather than a theological one. There is also St. Augustine's interpretation where permanent residence is only feasible in the kingdom of heaven, the city of God. Now, in modernity, we have a social contract tradition in which the individual is not part of a pre-given organic whole, but a separable and autonomous subject. The constitution of a political society requires resisting some tendency to act only on private interest and a mental act of consent to a permanent commitment and its fundamental terms. The political bond that is formed creates a commonality more important than any pre-given homogeneity. Now, Kant's conception of social contract is, in my point of view, closely connected to his radical conception of cosmopolitanism. Kant refers to an initial common property of the earth by all mankind. So, declaration of territory and the coming division of the earth in different territories is justified only in virtue of the fulfillment of the transcendental duty of public law, which is essentially enter into a social contract. Even more, all territory is provisional until all people enter such contracts. That is, all humans become citizens of states governed by law. But still, territories, even not provisional anymore, do not count as prohibitions of free movement. Arthur Ripstein notes that Kantian states at their borders operate like the innkeepers of Roman law. There is a universal duty of hospitality in the name of the universalization of law as condition of freedom for all human relations, of citizen to citizen, state to state, and state to foreign citizen. But there is an obvious asymmetry in cosmopolitan duty. On the one hand, it is universal in form, and it is a claim right. It's a legal right, the right to hospitality and peaceful passage, but it is relatively narrow in content, and is most importantly, it is disconnected from any aspiration of permanent integration of the guest. Kant talks only about a discretion to offer a contract of beneficence for long-term settlement. No naturalization is offered, which is unlike Rousseau, for example, who is not very fond of naturalization, but refers to it as a way of reproducing the political community. I think that Kant is heavily influenced in this from his abhorrence to colonialism and the dangers that are associated with permanent settlement. So we might try a different reading of Kant and a more holistic reading of cosmopolitan right. Could we trace such a possibility for more permanent settlement further than just hospitality and permanent bonds for the guest with the host country? One start of a way around could be to examine the so-called right to exit the political community or right to leave. In John Locke's theory, even in an already established social contract, we have the descendants of those who formed it, when they reach adulthood, have to approve it. So this mental act of approval is required again. By Locke, one can also abandon a social contract and enter another already established. For a mère de fatelle, there is a right to leave one's community if the ruler tries to impose a state religion. This is not far from John Rawls' addition of a right to leave concerning the decent hierarchical states as a counterbalance for the lack of some important liberties in these hierarchical states, which are not liberal. Kant is conservative towards the right to leave, if meant as a total renouncement of the membership to a community. And I think this is possibly because of his reluctance also to accept the right to revolution. That is, if we decide to leave a political community, in a way, we are judging the laws of the community. We don't like them, so we go above the law, which for Kant is inconceivable. But if we make this concession and accept a certain right to leave, then we must presuppose a certain possibility to be received, not 100% corresponding to one another, but some space for it. I think a possible answer in the Kantian theory to expand the cosmopolitan right in a reasonable way lies in Kant's doctrine of virtue and its possible relevance with the expansion of laws communities, in other words, republican states. Kant refers to cosmopolitan mindset, weltbürgerliche Gesinnung. A republican state must be inclined to act generously without anticipating immediate reciprocation. Caroline Reinhardt, a contemporary philosopher in Germany, a political philosopher, argues that beneficence towards our guests obliges us to consider citizenship for migrants that have stayed long enough. But is there a possibility that the Kantian theory includes also some kind of a non-ideal part, some kind of room for perfection? Kant is talking in the Metaphysics of Morals about the elevation of mere subjects or imperfect citizens, like women, he refers explicitly to women in his time, to full citizenship through their work and the society's recognition of their equal status. Drawing inspiration from this, Konstantinos Papageorgiou, a Greek philosopher, identifies a deeper reason to save refugees, this kind of guests, this guests that come to us out of need, in our conviction that all persons must live as citizens and thus be offered the chance to become citizens again when they have been diminished to mere subjects or even when they have been ostracized. Only by securing a life of full citizenship, either in their homeland or if this is not feasible in the receiving country, do we confirm our own commitment to consider one another free and equal in our own country. So from a duty of beneficence to the welfare of the other, we move to a duty to our collective democratic self. We might move, this is a suggestion. If we adhere to a cosmopolitan mindset then, grounded in the universality of the duty to live under conditions of freedom and equality, then we must carefully build a collective identity that is fairly open to integration of foreigners that have a genuine wish to achieve it, this integration. The conditions they must meet have to be provided by laws so that relatively stable and publicly intelligible and justifiable provisions motivate the resident alien to approach and adopt our preferred virtues or traits. On the other hand, total discretion or exclusion are incompatible with cosmopolitan law and may hide the hypocritical stance that aims at attracting workforce while totally disregarding migrants' social ties to the host countries, their demands of political participation, and the increasing political and psychological distance they have to towards their homeland. To conclude, naturalization is not exceptional, but it is normal and to some extent even desirable way to renew the composition of our communities. It is not a pure matter of sovereignty, but a subject matter for laws. It has to be present as a possible final destination for the refugee, the immigrant, or the guest worker, and must always be visible in the exchange with the alien. This is the cosmopolitan mindset. Without this motivation, the universality of hospitality might turn to mere pretext for exclusivist politics that also harbor the danger of internal divisions around purity of the nation and or superiority of an ethnic, religious, or ideological majority. Regarding the guests as potential co-citizens does not mean only conferring them more rights, but also more responsibilities, and does not necessarily entail the abolishment of the traditional traits and virtues that we hold dear. It can also be a sign of strength, adaptability, and attractiveness of our nation. In the end, and this might be a reference to what we discussed yesterday, the entitlement of a person to be member of a social contract, either in the constituent moment or in the subsequent constituted period of a nation can never be certain on purely empirical or essentialist terms. How can we be sure if it's the inhabitants or those who speak the common language? Who are the members? How can we describe it in a legally telling way? What actually matters is the mutual commitment to live under laws. And this is, in essence, equally important for the native, the member of the minority, the majority, the resident, and the friendly alien, the alien who comes on friendly terms. It lies then with our laws to strengthen commitment and responsibility and render the virtues we are proud of teachable in a way and adoptable by the foreigner, and also attainable and take it and be able to be taken seriously by the whole political collective. Thank you.
Thank you very much. Sofya will give you the word in a moment. We'll just see how to proceed. I lost the. You still see the shared presentations? Oh, yes, I know it. But online, are our presentations still visible? Because they still have the interface as if they were, but they don't have the button to stop sharing. So that is unusual. Sofya, do you see a presentation on the screen or just our video?
I see this blanket white screen. Just it.
So you see,
and this is yes, this is someone else's presentation about narrative
yes,
systems.
I have never had this.
Maybe I could share my screen.
Well, yes, I'm going to make you presenter now, and
so I'll try to
share your screen and hopefully that. Yes, it's working. So our next speaker is Sofya Koval, who will be talking about the late stage of Ronald Dworkin's philosophy of law and legal eliminativism.
So I guess it's this one. Here. I'm starting from so you see, yes, my presentation. Maybe
yes,
I should.
Maybe you could full screen it so it would be a little bigger, and that.
Yes, okay. Yes, I guess I see that you see.
Yes,
my name is my name is Sofya Koval. I'm from Moscow, Russia, Higher School of Economics. I'm very pleased to be here. Thank you for my colleagues that mentioned this conference and send link for this conference. And also, I'm very happy that I have an opportunity to present my paper online. It seemed very important for me to keep in touch with international legal philosophy and theory community. So today I'll present you it's a piece of my main paper about Ronald Dworkin. It's about his late stage of his philosophy of law, and I'll try to find connections with legal eliminativism. So I guess that first of all, why late stage and how many stages are there? So I divided legal philosophy of Ronald Dworkin by 3 stages. Early stage focused on rights and legal positivism in taking rights seriously. Middle stage is about interpretivism, and late stage, which I am going to talking about today, it's a shift to one system picture. So the transition from one stage of Dworkin's legal philosophy to another was always accompanied by changes, not great changes, but changes of manner of analysis and his methodology. Thus, in Law's Empire, Dworkin emphasized that he changed his methodology from the phenomenology of adjudication contained in Talking Rights seriously to an interpretive understanding of law. The next late stage was also marked by innovation, let's say like this. In this book, Justice for Hedgehogs, Dworkin focuses, in his words, on the hottest of the chestnut, namely the issue of relationship between law and morality. So, about late stage. The beginning of the late stage of Dworkin's legal philosophy can be considered around 2006 or 2007 till his death in 2013. So this stage and this period marked by Jeremy Waldron in his work Jurisprudence for a Hedgehog. He wrote that Dworkin took a more challenging position on the relationship between law and morality. He said that he merged this position already in Justice in Robes, but finally he established his final view in Justice for a Hedgehog. So at a later, I show you this table of content of Justice for a Hedgehog. It's very important because at this stage he paid less attention to legal philosophy, and he was more concerned with question of ethics, justice, political morality, and this paper he contrasts his ethical monism with ethical pluralism of Isaiah Berlin. About this later stage, he accepts integrated conception, which finally blurs the boundaries of legal and moral, which is most anti-positivist thought that we could imagine. And Dworkin rejects the traditional two-system view, separating law and morality. Proposed this one-system picture and equalized legal judgments and moral judgments. And then he this is the part of discussion about the subject matter of legal philosophy, and he believed that law is a branch of political morality, not independent part, but it's a branch of political morality. So let's talk about new anti-positivism, which is lately legal eliminativism. So by the mid-2010s, interest in interpretivism of Ronald Dworkin and hard Dworkin debate had waned. So we know that maybe 40 or 50 years it was a hard Dworkin debate, talkings and writings about it in academic and Anglo-American life. So by the mid-20s, I guess that everyone was tired about this hard-working debate. And surprisingly, this book, Justice for Hedgehogs, eliminate and raise a new question about relationship between law and morality. So the publication of Justice of Hedgehogs allowed this theory to be spoken and written about again in a new light. And despite Dworkin's predictions that collapse of the word of law and morality into one system may seem absurd or paradoxical to some. So in this paper, Justice for Hedgehogs, he wrote that maybe his main thought about one picture system is very, funny and ridiculous for legal positivists, and maybe no one will accept this point of view. So this concept of one system picture was accepted by younger generation of legal philosophers, and one system view of law has become the basis of a new trend in legal philosophy, was called legal eliminativism or new legal anti-positivism. So this one. So legal eliminativism. Eliminativism sets the picture apart from positivism and insists that the question that what rights, obligation, privilege, etc., generally moral question. So it is I quoted Scott Hershowitz and his paper The End of Jurisprudence. So all these questions that legal philosophers, especially legal positivists, thought is legal questions are moral questions for legal eliminativists. So let's talk about key figures of eliminativism. First of all, I forgot to write down their names, sorry, but I think that they're well known. So first of all, it's Scott Hershowitz, it's Lewis Cornhouse, and maybe it's the main question of this paper, Ronald Dworkin. So according to Australian researcher Hilary Nye, I will mention her later, the eliminativist approach can be found in the work also of Leah Murphy, Dan Priel, Brian Tamanaha, and Mark Greenberg. And also she mentioned Ronald Dworkin, but about him we will talk about later. So Scott Hershowitz writes that all this, so I mentioned already, all these questions are moral questions. Also, eliminativism attempts to overcome the old model of questioning about the law. Yes, so not about the nature of law, legal conceptual analysis, and so the main reason and the main and the key third of legal eliminativism is to change this old model and abandon conceptual analysis. So the favorite method of legal positivists, which for many years dominated Anglo-American jurisprudence. And I think this is my next research is about how legal positivism and conceptual analysis is still, still dominating this our legal philosophy field. So Hershowitz believes that jurisprudence should seek an answer to the question of how legal practice affects moral rights, not vice versa, and also discard the metaphysical question posed in the debate between hard-working debate about the essence of law, since there is no reason to believe that legal practice gives rise to the legal field as an entity. So legal field for Scott Hershowitz and legal eliminativist, not an entity. And so the first consequences of this, that we cannot find the nature of this entity if we have no entity. In addition, Hershowitz, Lewis Cornhouse, consider himself as legal eliminativist, which is more important for me. He considered Ronald Dworkin as proto eliminativist, so like the key figure before eliminativism, but not eliminativist entirely. So now we can ask ourselves two questions. So may we call Ronald Dworkin a legal eliminativist? And if we may, since when he was a legal eliminativist? Maybe from the start, maybe just from 2011 when he wrote his Justice for Hitchcocks. So let's find answer to this question and consider several papers about Justice for Hitchcocks. First of all, it's Jeremy Waldron, who wrote in 2013 paper Jurisprudence for Hitchcocks. It's post-humoral paper in honor to Ronald Dworkin, so this is the paper. He called Ronald Dworkin Ronnie. They're in very close relationship. So Jeremy Waldron emphasized that Justice for Hitchcocks present the radical position that the legal arguments can be moral, but legal judgments and arguments themselves are moral. So for Jeremy Waldron, this book, Justice for Hitchcocks, was radical, entirely new position, even for Dworkin, who is famous for being the great enemy of legal positivism. So even this book is far more radical than his previous books. So this is the first position. Actually, Jeremy Waldron wrote less about legal eliminativism, so he didn't consider Ronald Dworkin as a legal eliminativist, but he emphasized that it was a radical position, so and a radical shift. So the next one is Scott Hershowitz. I analyzed his several works, End of Jurisprudence, and of course his newly just maybe half a year published Moral Practice, Law is a Moral Practice. So Scott Hershowitz wrote that it was only at the end of his life that Dworkin came to see his mistake. So not like Scott Hershowitz didn't mean that everything that Dworkin wrote was a mistake. Of course, it's not an act of disrespect, but as a legal eliminativist, he finds this eliminativist position and stand only in Justice Hitchcock's. So in Justice for Hitchcock's, he said that he never should have accepted a two-system picture, only one system picture. Also, Scott Hershowitz, and in this book, as stated in the publication description, he wrote that a neglected tradition of legal thought most famously associated with Ronald Dworkin. So it's directly written that Scott Hershowitz thinks that Ronald Dworkin's one system picture is a main source and root for this new legal eliminativism. So let's divide his positions. First of all, he thinks that he made a mistake and then he changed his mind in a rightly way. So he accepted one system picture. This is so it was like Jeremy Waldron said, a great shift. And secondly, I think that he considered Ronald Dworkin as, like Kornhaus said, a proto-legal eliminativist. So the next researcher that I should mention today is a Hilary Nye. So she wrote these two brilliant, I guess, articles. Does law exist? Eliminativism in legal philosophy. And the second one is about Dworkin system view and Dworkin's anti-Archimedean eliminativism. So her position now considers Dworkin anti-Archimedean one system picture of the late stage to be a type of eliminativism, since unlike the positivist. So she wrote, Dworkin resists placing law in the field of facts and believes that it should be placed in the field of values. So for Hilary Nye, she insisted that Ronald Dworkin's legal philosophy was always in the vibe of this eliminativism. So he was eliminativist maybe less in the beginning of his career, but he was eliminativist like always. And this is the so this position is different from this position of Jeremy Waldron and Scott Hershowitz. So Jeremy Waldron and Scott Hershowitz is on this team that Dworkin changed his mind, and Hilary Nye thought and still thinks that he was always legal eliminativist. So I should mention that again, that according to Lewis Kornhaus, that a picture I show you previously, recognized Dworkin as a proto-eliminativist. And also Dan Priel so believed that Dworkin rejected the fundamentalism of legal positivism and its central question about the essence of law. So what I should say that we should analyze all that is what was said by different researchers, and I think that I should share with my point of view. However, the radically of Dworkin's transition from a two-system picture dividing morality and law to one system picture need clarification. So, is his thesis about a one system picture was so unexpected for the world of legal philosophy? I guess for legal positivists it was more shocking than for anti-positivists, of course. And I think that despite his rejection of interpretivism, so in his later book Justice for Hedgehogs, he rejects two-system picture of Law's empire, and also he wrote that he rejects interpretivism. But we should clarify that he did not reject interpretivism as a method. He still thinks that practice is important for legal philosophy. Legal adjudication is important for legal philosophy. Also, interpretivism is a part of analyze everything that around us. So this practice, also legal practice, we should interpret it in all kind of ways. And in this point, he rejected interpretivism as a part of two-system picture, not as a part of like a normal way to interpret practice. So I think that we should mention also that Ronald Dworkin didn't make this kind of crazy for legal positivist shift in Justice for Hedgehogs, because he already in Justice in Robes, he mentioned this shift. And actually it was like a pre-Justice for Hedgehogs work, I guess. And what is more important, in this chapter Law, which is the final chapter of this entire book, Justice for Hedgehogs, he wrote, "This chapter is meant to supplement my book Law's Empire and Justice in Robes," so these two previous, not substitute for them. So Dworkin directly wrote that Justice for Hedgehogs is not a great shift, and this final work rejects all previous work by Dworkin. So I think that step by step, Dworkin came to this idea. It wasn't a radical shift for me. In this collection, Justice in Robes, published in 2006, we can find a hint of the further turn towards to this one system picture in Justice for Hedgehogs. So I guess I have maybe 1 minute left, and I should mention that not every eliminativist is a Dworkinians. So if you accept Dworkinian way of legal thought, it doesn't mean that you're eliminativist. Or if you are an eliminativist, it doesn't matter. We cannot say that you're Dworkinian. So researchers argue about whether Dworkin can be classified as an eliminativist. Because we cannot find this direct evidence. But I think that we may find that Dworkin moved from this, hegemony of legal positivism and metaphysical question about what is law. But I think that we should accept this one argument that Ronald Dworkin was a part of hard-working debate for so many years, and his main narrative of thinking about law maybe was quite conceptual. So I guess that according to this academic style of debating between Dworkin and Hart, it was half conceptual debate. And if we pay attention not to this debate field between Dworkin and Hart, I think in this case we may say that Dworkin was proto-eliminativist. I shouldn't say that he was eliminativist at all, because like my supervisor likes to ask me, was a Marx a Marxist? So let's say that Dworkin was not Eliminativist, but proto-Eliminativist, so like a great source for this new approach in legal philosophy. So I guess that I tried to, to control myself with the timer. So thank you very much for your attention. And I guess that questions further, yes, and after presentations.
Thank you very much, Sofya. That questions will be after all presentations, so please stay connected for after the next two papers. And now we are moving on to Olcay Karacan, who will be talking about narratives and the quest for justice, sharing experiences in legal education.
First of all, I want to thank the organizing committee for this organization. I am Olcay Karacan. I come from Turkey. I work at Çukurova University in Turkey. I want to share some experience in my teaching teaching experience. Okay, I can start. Narratives and quest for justice, sharing experience in legal education is my topic. You know that alternative educational methods in legal educations are generally discussed in the context of providing students with critical thinking skills. Of course, students need to acquire critical thinking skills. However, critical thinking skills are not enough for students to engage in an effort to seek justice. From this point, I have two claims. My two claims are interconnected, so I will argue two interconnected things in my presentation. First of all, my first claim is that in order for students to become lawyers who will contribute to quest for justice, critical thinking skills should be taught in a way that will not discourage them finding a way against injustice. Sometimes critical thinking can discourage students. Not always support, sometimes discourage. My second claim is that since alternative narrative show us my second claim is that alternative narrative show us that we are not helpless in face injustice. The inclusion of alternative narratives in legal education can increase the courage of students to fight against injustice. I want to start my first claim. My first claim is that students should be taught critical thinking skills without discouraging them from fighting injustice. Of course, we know critical thinking gives students perspective to understand injustice. I don't deny the importance of critical thinking. When we limited only critical thinking, students can feel helpless. We must support critical thinking, some virtues of courage, hopefulness, thoughtfulness, etc. However, what is important here? How students are tried to be taught critical thinking skills. First of all, we cannot develop students' critical thinking skills may make them passive objects of knowledge. We must not treat them passive objects. This is only by telling them critical legal theories. I repeat, critical legal theories are very important for repeaters to able to think critically. However, I would like to say the method of teaching and learning critical theories are also important, being able to think critically. Sorry. However, I would like to say that method of teaching and learning critical legal theories is also important for being able to think critically. Referring to the words armchair philosophy, you heard yesterday, which I liked very much this word. I would like to say that talking about the critical theories to students like armchair professors is not the useful method for students to gain a critical thinking reasoning. Teaching students legal theories by combining these theories with unjust court decisions actually result in passive objectification of students. When students become object, it is not usually provide them with critical thinking skills, even if it is possible, no matter how important the theories taught them are. When we treat students as if they were simply learning objects, students fail to realize their own potential to fight injustice. When students fail to realize their own potential to fight injustice, they feel helpless in face the injustice. In short, I would like to say, in addition to making students realize injustice, the necessity of providing them with the courage to fight against injustice should be part of legal education. Why? I'm sorry. Why students don't realize they have the potential to fight against injustice, they found themselves in a learning helpless in the face of injustice. From this point on, we should focus on the way we establish relationship with critical legal theories. In other words, we should consider these theories together with the aim of increasing the courage of students. In this direction, instead of starting with abstract equality and justice theories should not have us. We should try to understand the perspective of people who experience, concentrate inequalities and injustice together with students. However, in order for the experience of seeing this injustice together provide the motivations for the struggle experience, it is very important to come face to face those who cannot access justice together with students through methods such as law clinics, strict law, etc. I'm sorry. Once encountering injustice face to face, doing something together with students against this injustice will cause students realize their own potential. When encounter students face to face, of course, it is very important for them. In the context, but my presentation is not directly understanding of this work. My presentation is grant or legal clinics, not legal clinics safe itself. In context, while students' awareness of injustice practice, students' understanding of credible legal theories can lead to desired fight against justice. However, my presentation is more related to my own experience of encouraging my students in my literature of philosophy of law course, which prepared the ground for core law clinic discourse to seek justice with alternative narrative. Alternative narratives as defend legal clinics background. And in line with my experience, I will try to explain my claims supporting law school students with alternative narratives how can increase their courage. However, okay. However, alternative narratives are not limited to narratives work of arts. Liberating stories in their lives, discourse created to create public opinion against injustice surface in court can be considered alternative narratives. In short, every discourse that allows different voice to emerge for protection of right can be considered alternative narratives. Of course, not every narrative provides a perspective, goes beyond the traditional interpretations and other ways it's possible. I accept. Although dominant narratives sometimes cause the powerful to make injustice seem natural, even if they do not make them seem natural. At least to make people believe it is not possible to combating this injustice. For example, myths, which are dominant narrative type that we all know. Myths can also considered a dominant narrative type, seeing and showing the world through the eyes of powerful peoples. For example, the myth of woman, the housework normalized, which fact that the fact that housework is mostly done by women, not as an unjust situation, but as a natural situation. Here, alternative narratives are necessary to prevent injustice from being normalized. Alternative narrative never normalized injustice, although alternative narrative are prevent a severe injustices are not normal. Alternative narratives are limited to questioning the preconceptions of the dominant culture, but they also create a desire in people to fight against injustice because they show something else impossible. In the law and literature and philosophy of law course that I teach at my faculty, I often use alternative narratives while trying to raise awareness of that fighting against injustice independent of people. Fighting against injustice is dependent of people is very important. Sometimes we forget this idea. In my court, in my course, I want to explain. I want to give an explain. In my law and literature course, you know this novel, Toni Morrison beloved novel. We evaluate our students. The novel below is briefly, I can say, main character is Seth, who works as a slave on a farm with her children, her husband, and her 3 brothers. Seth, who cannot stand the condition of slavery, tries to escape from slavery. She is saved from the slave hunters just as she is about to catch. However, Seth can catch. They can escape Seth, and Seth take her freedom. But when Seth fighting, she kills her daughter because she doesn't want her daughter be slave. In this novel, Seth's mother-in-law takes 7 children from a farm owner as soon as they are born. Her in-law's mother's 18th child was born. Seth's mother-in-law could not take her child, could not look her child in the eye because she feared that it will be difficult her to look her child's eyes. Based on the novel, we try to create a follow perspective with students why freedom is vital for the people, and that is possible to gain freedom even in the most difficult condition if we struggle. In this course, we discussed how unjust slavery is and how is it not enough to criticize its own, and we have the potential to escape from slavery. Morrison novels help us. Also, in this lesson, we are not only discussing this novel. A lot of narrative we can discuss, but I can only give you only one example because we have very limited time. But these narratives, I only give only one narrative, but all this narrative give us encourage. I can make. Students think we can make. I am not a passive or I am not subjective. Students think I can't make. Students can't feel their self helpless. Of course, alternative narratives are not limited literary works. However, alternative narratives are not limited in novels, etc. Liberating studies in our daily lives. Of course, alternative narratives. Discourse created to create public opinion against injustice. A discourse created to public opinion against suffered in court can be considered alternative narrative. In short, every discourse that allows different voice to emerge for protectant of light can be considered alternative narrative. In this context, in my philosophy of my course, we wrote rewriting decisions with the student. This rewriting decisions motto is, if I were judge. In these studies, we try to write better decision more than judges. Or time limited, so I can give only 2 examples. Narratives broaden students' perspective. Therefore, based on my experience in love and literature lecture, philosophy of love course I teach, I will express that it is not enough to give just give students a critical perspective. And supporting students with alternative narratives that are both of that help students to see and seeing injustice and seeking justice. I finished.
Thank you very much. I see Sofya has told us that something has come up and she needs to go. Sofya, are you still with us? Do you have a few minutes maybe, or have you gone already?
No, I'm here. I have a few minutes, but I should go maybe in 5 or 10.
Monika, if you don't mind, since Sofya will have to leave us earlier, can we just take 5 minutes if anyone has questions for Sofya now? So for the previous presenter, are there any questions for Sofya? Thanasi has one.
Hello, Sofya. We were in contact with Thanasi. I have to say on one side that I have to make a comment. Don't take it too harsh, but on one side, I understand and I fully support online participations. And we had a discussion within our network whether we should have them or not. And I think that what you said in the beginning of your presentation, that this is a way of you for staying in touch with international academic community, is exactly the reason why I think we should have online participations. But it would be also nice to have online participants fully present during the conference. Don't take it too harsh. We had only Isabel, to be frank, who has been all this time with us, and I think it should be said. So on one side, I think it's very good that we have online ways of participating in the conferences, because it gives possibility, first of all, for us to hear those who cannot come, and those who cannot come can also participate with us, and we can learn from each other. So this is the first comment. Don't take it harsh. I just needed to say it because in principle, we had this discussion within our network, and I think we should keep online participations, but with that kind of remark and precision that if people participate online, they should be present as well online all the time. Now, just I say this because I found your presentation very interesting, and I think it fits well into some other panels sessions within our conference. Now, if you could just clarify to us where does this turn come from in Dworkin's philosophy, from two-picture system to let's say integrist or integral way of approaching to the role of judge, and the Hercules, which he actually develops already in the Law's Empire, the concept of a judge which should be able to find a solution for every possible legal problem, matter which occurs before him. So where does this twist in Dworkin's philosophy come from? How do you explain it?
Thank you. First of all, for first comment about online participating, I fully agree about it. That's because I think that conference is a great time to communicate with each other. And I actually, due to this conference is online for me, I was rejected to make it like a business trip and to be free from my classes. And I had, my Tuesday, from Monday to Saturday, I have classes all day, so I had no opportunity to be fully involved, which is for me is a great disadvantage of being conference online. So, but I fully agree with you. Not taking it in a harsh way. So thank you.
Thank you, Sofya. Thank you for understanding as well. Thank you.
You know, I would rather be in Belgrade than in Moscow right now. I fully assure you. Secondly, about where and when can we, you know, feel like that Dworkin turns from this one two system picture to one system picture. I guess that it's we may find directly evidences in Justice for Robes, so in 2006, this book, and but many researchers like Hilary Nye and her supporters, they think that we may say that he was Eliminativist from the beginning, and he did not accept this two system picture because of, you know, these academic circumstances that he was like in this conceptual analysis debate, and he needed to be in the frame of it. But I think that we should be like really researchers and find evidences. So main evidence is Justice in Robes, when he first mentioned that he turned from this two system picture to one. I think it's this book.
Thank you, Sofya.
Thank you. I think we have two more questions. Professor Theophila online, and then Professor Voutsakis here in the room.
Thank you so much. My question is about the one system paradigm that you describe in the perspective, in Dworkin's perspective. My question is this one. Would you call the one system political morality, or would you call it morality? You know, the whole system is not law, for sure. Is it political morality, or is it morality? In your thoughts and in your interpretation of Dworkin. Thank you.
Thank you so much. I guess I'll answer strictly that I guess that Eliminativist wider spreadist approach to moral sphere in general, and I guess Ronald Dworkin he used this political morality as a part of to live well in this life, and this is part of ethics, morality, and then political morality. So I guess he considered law as a part only of political morality, and then like a tree. So the final boss is ethics in general.
Professor Voutsakis.
I would like to thank you for your talk. I also say that I find this one system picture very interesting and persuasive, and I furthermore think that it was from the beginning on in the work of Ronald Dworkin. But nevertheless, there is a question pending. Even if we accept this idea of having a single system, within the system, law is something distinct. In other words, is law and morality, are these two elements overlapping, identical, completely the same? If not, to what extent do they differ?
I guess I think that we should use this way of understanding morality and law, not like a tumbler that like turn on it's law, turn off it's morality, or vice versa. I guess that we should think, when we're talking about the work in Eliminativist and Positivist, that at different stages of understanding how law interacts with morality. as I understand working as eliminativists, that eliminativists more, aggressive in this way. So they collapse morality and law and reject to consider law as entity. So it's like nothingness. It's like this, but it's not like nothing. It's just moral judgments. So law, it's like a nickname for moral judgments, but in a different way. So I guess eliminativists more, more about morality in general, and Dworkin is about, to separate law. So I guess that Dworkin is so like a person from his time. And I guess that his final stage of reject this two-system picture, but I guess that didn't want to do what did eliminativists, to collapse it in one moral sphere without acknowledging that this is law. I guess I should interpret Dworkin this way.
Thank you very much. So thank you, Sofya, for your participation. And now I'm opening the discussion, and I think Professor Padin has a question. Just please turn the microphone on. Just the microphone. No, you have to turn it on, the button.
Was Socrates right when he drank poison rather than leave the city in light of Aristotle's Nicomachean Ethics? Yeah. Let me remind you why. Aristotle says they have duties towards others. I mean, I'm now translating virtue ethic into rights ethic, which may not be appropriate, because they may not be commensurate. But anyway, you understand the basic idea. So we have duties towards others, and we have duties to ourselves, right? Being a moralist, I'm cultivating, however, I'm developing my wisdom. And my wisdom is of potential use to others, right? So if it is of potential use to others, then it may be a part of justice, a subject matter of justice. And if so, if I'm a moralist, if I kill myself, I'm no longer a moralist. I cannot be of service to the others. Would that follow from what you have said? From what Aristotle said?
Okay, thank you very much for your question, because it's really pointing to the issue. Two ways of answering. The first one, from a strictly Aristotelian point of view, you cannot be just or unjust to yourself first. Then the question is not if Socrates was just or unjust in killing himself, because justice is structurally intersubjective. First point. The second point, why did Socrates in Crito kill himself or accepted to drink poison? Because it was the only way to be an individual, what he ever since was in his life regarding himself and regarding his polis. What he is doing is not to obey the law, period, is to obey to himself as citizen, because he always lived as a citizen in his polis. You may say, okay, Socrates decided this. Good. But the idea, where is the link? Where is the link? In my opinion, the link is that in the Platonic Aristotelian tradition, justice is the condition to be human. And to be human means to be intersubjectively connected. And the decision of Socrates is an intersubjective decision. I'm not who I am if I extrapolate myself from my community. Can we accept this for our present morality or way of thinking to moral duties? I don't know, but it's challenging for us, I think, because the idea in which we think justice is close to the idea in which we think mankind and humanity. And this is the challenging point in the Platonic Aristotelian tradition. So it's my
But then
point.
the duty towards myself to cultivate my individuality is overriding. It is stronger than my duty to be just. But perhaps it's totally inappropriate because I'm again translating virtue ethics into rights ethics. And perhaps there's some measure and
I think that
I just wanted to make that point. Thank you very much.
The point is
Sorry.
virtue ethics is not only rights ethics, it's also duties ethics. And the idea for me is challenging the Aristotle point of view is that if we accept this point of view, then perhaps we can start to think in terms of not only of human rights, but of human duties.
Human duties, yeah. Sure.
Okay, this is the challenging point in my.
Thank you very much. Thank you.
Thank you. Do we have any further questions? Yes. Thank you. We have a question from Professor Oklopcic. Just a microphone.
I have a question for Stefano. Correct me if I'm wrong, because from my very, very modest reading of Aristotle, I understood that polis is not the expression of koinonia. And when we talk about political community and make these connections, I worry that we are being anachronistic because the purpose. So koinonia and polis don't stand in the same relation as the people and the state of today. The purpose of polis is for excellent living, right? It's not for the purpose of living together. And which brings me to a broader, and I mean that's basically a question for all the Greeks on the panel. Being Greeks, they're natural authorities on everything Greek, including Aristotle. So feel free to comment. But the bigger worry is about our underlying schematic pictures of constitutional government, which are at their base world pictures. So in Aristotle, it's completely obvious that when we talk about the constitution of a polis, he talks, it needs to be on a slope, it needs to have beautiful walls, there needs to be a gym for old people, there needs to be a farmer's fresh produce market and temples. So it's a contained, built structure, and crucially now, around which there is nothing, right? Mentally, well, there is a hinterland and villages, and they gravitate. It's a radically different picture from a modern state. And actually in Cicero, you have it even more clearly where he says, oh, the cities, the republics are spread out like specks around the world. And the reason why I'm mentioning this is because we rarely talk about these underlying schematic pictures, and we don't ask ourselves, have we secretly, maybe including Kant, assimilated those that are simply no longer correspond to reality? So the image of a stranger, extraneo, right, from the outside, the image of an alien, al in a Proto-Indo-European, beyond. The etymology of a foreigner, foris in Latin, a door. So that's the image of Conan the Barbarian, where they come to the village and slaughter Conan's mom from the outside, right? That's the mental image of which gives this weirdness and menacing quality. So I'm elaborating because I think it's pregnant with political effects and consequences. But take this image of kind of archipelago, kind of existential dread and anxiety, who's going to come from the other side of the hill, with Kelsen's image. And I swear to God, I don't understand why this image, literally the picture of a state, is not more popular, because it's so cute. So in the general theory, when he talks about the concept of a territory, he says, well, you know what? The previous theorists are wrong. It's not a delineated part of Earth's surface. It's an inverted cone. So it's a three-dimensional picture of a state where the boundary, which in this picture is a wall, right? A city wall or a house wall or something. It's a membrane. So that we're not in an archipelago. So the world is more like your bathroom, right? With tiles. And maybe part of the problem is that we have a word archipelago, but the thing is called tessellation. So you are not I'm not saying that you should think that way, but we are at liberty to think that way. When you go to Hungary, you don't cross no man's land. You immediately are there. So the problem is of circulation, of kind of regimen between these boundaries. And the reason why I'm kind of exercised about this is because this puts the picture of the hospitality, etc., in a different light. It's just one of the problems of world organization. So I may be against hospitality toward foreigners, not because I'm a bigot or a nationalist or a really bad person, but because I think we have different priorities as human beings. So I'm not saying that, for example, Giorgia Meloni is such a wonderfully kind of cunning human being or thinker. She's onto something when she flips the script and says, well, let's talk about the exploitation of African populations in Africa. And when she links those two things together. So you are not necessarily, you may do it for sinister purposes, but that's a completely legitimate move to make. That doesn't make you a nationalist. That actually, if anything, that makes you more sincerely cosmopolitan than a cosmopolitan like Kant, who is basically simply updating the old nationalist pictures of distinct territories, and he's very clear about it. And okay, the globe is circumnavigable, and we can go everywhere, and because of that, we can't avoid bumping into each other. But the basic default picture is the picture of separate, distant villages, which I think is in need of updating. Thank you. So community.
You first. I think that formally the question was addressed.
Okay.
Okay. It was addressed to you first,
Okay,
so you can make
the first one. I have not answer to your question, only some remarks. First, I begin with a saying in Italy. Maybe you know it, about hospitality. We are so hospitable people, but we have a saying, a guest is like a fish. After 3 days, it smells. Okay. First of all, okay. Second, barbarian. You're right. Polis is something quite different from the modern idea of state, not the contemporary, modern idea of state. Hegel spoke about the schöne Sittlichkeit. Huh? It's something which we have lost. Perfect. I agree. But about barbarian, take for instance the tragedy, the Perse of Aeschylus. Perse of Aeschylus, Persians, is the first time. So maybe I'm false, but it's where you have not the representation of the barbarian, but you have yourself represented from the point of view of the barbarian. Then barbarian bedeutet, means that they are human too. Okay. First, secondly, my point is, maybe it's really a trivial one, a very trivial one, but where you speaks about humanity and justice, you speak about something which is linked together. Okay, you can organize humanity in the form of a polis, in the form of cosmopolitan, but you cannot resolve this link, this bond. This is the only point I wanted to make. Okay.
Thank you for referring to images and pictures. It's important to think on those terms. What I would say is that I think there's an old saying of Nietzsche, who says that the ancient Greeks produced all these harmonical pictures, but their reality was quite different. So they find consonance in that. So I would interpret it in this way, that they were aware of things, but they chose to produce a more harmonical picture. So this is what I try to describe in this transition from a more theological concept of the stranger, with the barbarians and all this in the Politeia, and then the more accurate, and I would say some kind of modern approach of the nomoi, which is more, which is closer to what we would say something like a society of individuals. Okay, I'm not assigning such modern concepts to Plato directly. What is important, okay, I wouldn't, on the core issue now, I wouldn't defend any kind of politics of numbers. That is, that we have to be hospitable to great numbers of refugees or few numbers, or it doesn't have to do with that. And this is not the spirit of Kant, and this is not the Kantian revolution of cosmopolitan law. The revolution is that we're talking about law, about legal matters, and about law being the only condition under which we can be free. So Kant refers to this, has a picture, he uses a picture, although he's not very fond of depictions, the picture of sphericality of the earth. And he uses it to say that it is unavoidable in every possible movement or concept of movement not to stumble upon other humans. So what does this tell us? That law is the necessary condition for any exchange or relation. And this doesn't have to do with totally free global movement. This would not support something like that. But I sense that this notion of categorical and universal rights and duties under cosmopolitan law, and not cosmopolitanism in an abstract way, implies that we have to spend more effort in going from hospitality, travel, exchange, to more to ways of more permanent inclusion of foreigners. Because in the end, even the nation state might be a very nice idea, but has never managed to become so homogeneous and continuous in, I don't know, 1,000 years, 2,000 years, or without even history. Every history of a political community is a history of some kind of consent, theoretical or even factual, to some legal norms. And by taking this picture, we can picture also the possibility of coming closer between an organized community and a foreign person. And this, of course, does not answer every concern that exists in migration, but revolves around a new important, an actually important factor, which is law and the mutual commitment that law symbolizes. Hope this answers all the question.
We have another question, yes?
Yeah, thank you. I would like to ask, firstly, Vassilis, thank you for your presentation. I would like to ask a question about Kant. You know, the important concept of the Kant is goodwill, and then goodwill may criticize different ways. One of them, it is generally regarded empty concept. If I remember correctly, Albert Camus said that goodwill without enlightenment, it is nothing. What do you think about that? Second question is Kostas. Thank you again your presentation. I would like to ask about cosmopolitan egalitarianism or egalitarian approach of cosmopolitanism is enough to deal with foreigner problems. You know, there are many problems about the egalitarian norms of distributive justice. What do you think about that? Thank you.
Thank you, Curies. This is a perennial question, the question of the relation between will and its conditions. And I agree with you, this is a very difficult issue to handle with. Although deep down, I think for Kant, at least in the way I interpret him, it is possible always to dissociate these two elements. The goodwill is something that is important, and this is why Kant believes that even a person devoid of everything, a prisoner, can have goodwill under the worst possible conditions. It's something that it's important, and I think this intuition of Kant is very helpful when it comes to questions of rights. Deep down, what is a right is something that we have deep down between ourselves and ourselves. On the other hand, and this is also important in the case of rights, rights cannot exist in a vacuum. In other words, goodwill cannot exist without favorable conditions. But the point that I think Kant makes very clear is that these conditions that must be dependent on our endorsement, on our possibility of acceptance. It is to that extent that goodwill is present even in the way we treat the conditions that frame it. Thank you.
Thank you for this. This is the other important part of cosmopolitanism, global distributive justice. In my reading, Kant would not be very much fond of the notion of international distributive justice. I think this would partly undermine the autonomy of the political communities, since our first duty is to come together to political communities. If we do not prioritize our duties towards the other members of our own community, then these duties might weaken in a way that it would undermine at first our mutual relations and their thickness in a way. And on the other hand, I think this could be even more important for Kant. This would undermine the motivation for the recipients of the assistance or the help to pursue the strengthening and the autonomy of their own political community. And if we follow this radically anti-colonialist approach of Kant, then strong duties of distributive justice on a global level would seem a little bit paternalistic, I would say. He even says that even a people is very mature in some million way, we can help him and exercise administration on his territory, but this is only in the name of these people, and this is only temporary, and in general this is not acceptable. So every political community is entitled to have its own distributive justice principles and its own discovery or evolution of distributive justice. Hope this answers the question.
Okay, and that will probably be our last question. Just the microphone.
Okay.
If you could share with us your experience with alternative judgments as a form of working with students.
Rewrite judgment.
Yes, alternative judgment.
Rewrite judgment.
Yes.
Thank you for these questions. Rewrite judgment. Students, we can select some bad court decisions. Students, for example, incest. For example, child kidnapping, and then students and we together we analyze decisions which causes which court causes are bad, which reasons are legal reasons are bad, which legal reasons are good. They evaluate, and then we have a motto: if I were judge, I can. How can I write this rewrite? Some students only her or himself, or some students take a group, write decisions together, and we discuss rewriting decisions, and this process gains students to courage. Students think we can make better. I will give a good lawyer, good judge. I make them better than them. So they didn't feel they aren't feel helplessness. They help the students their liberation. They help them their liberation and their freedom.
Thank you all, and with that our time has run out, but we have not seriously overstepped it. I would like to thank all our participants once more. And now we are going to lunch here in the club again, and we will continue at 3 o'clock sharp.
Bye, see you later.
See you later.